No. They went on to say the judges in the Privy Council, the death sentence accordingly cannot stand. Their lordships consider that the only appropriate disposition of this case is that the appellant should be sentenced to life imprisonment, and that should be substituted for the sentence of death pronounced by the judge and affirmed by the Court of Appeal. Now, our local courts said the death penalty, but they said this is not the worst of the worst. I must indicate that the Court of Appeal had proposed, its view is that the death penalty is not mandatory, but it is the jury who should decide whether the death penalty is imposed or not. The Privy Council ruled, no, it shouldn't be the jury. It must be the judge. Now, there are several other cases which I'd like to draw to the attention of this Honorable House in which this matter has been discussed. I make reference to Pratt and Morgan, Privy Council case number 10 of 1993. I did the Daniel Trimingham case at the Court of Appeal was number 32 of 2004, and UK Privy Council 25 of 2009. Then there are the cases from St. Kitts of Mitcham and Fahy is pronounced up there, but we will call it Fahy, F-A-H-I-E. Number 11, number 10 of the Court of Appeal of 2002. That also, Patrice Matthews was involved in that matter, and that matter went up as Privy Council case number 5 of 2009. And then there's the case of Mervyn Moise, M-O-I-S-E, out of St. Lucia, number 8 of 2003. So, Mr. Speaker, when this government committed to carrying out the death penalty, but have our hands completely tied in practical terms, reflecting what we thought the country was saying, we went to have the Constitution amended, and this is what we had in the Constitution, the proposed Constitution, which was voted down by the people of this country. Section 26 of this proposed Constitution, which was voted down, amended the provision on the protection of right to life by adding a third subparagraph saying, a person shall not be regarded as having been deprived of his life in contravention of this section if he is subjected to capital punishment in accordance with Section 29 of the Constitution. In other words, the Constitution, this proposed Constitution, which was voted down, said, never mind this issue of the right to life. We are making it explicitly clear, where it was not that clear, that a person shall not be regarded as having been deprived of his life in contravention of this section if he is subjected to capital punishment in accordance with Section 29 of the Constitution. And then Section 29. This is the section which says, deals with the protection from inhuman treatment. We repeated what the existing Constitution said, that no person shall be subjected to torture or inhuman or degrading punishment or other treatment. But we said many things else and added several subsections to make it judge-proof, that it was going to be impossible for judges to get around what we had put down here. First of all, in subsection 3, we took on Pratt and Morgan, with that limitation. Subsection 3 said, no objection shall be taken in or by any court to a sentence of capital punishment being carried out within 1 year after the exhaustion of all proceedings embarked upon and diligently pursued by the person thus sentenced in any court or tribunal or other body in the jurisdiction of which is recognized by or under the laws of St. Vincent and Grenadines, whether such court or tribunal or other body is located inside or outside St. Vincent and Grenadines, at which the imposition or passing of such sentence may lawfully be appealed, reviewed, challenged, questioned by the person thus sentenced. In other words, we are saying, Pratt and Morgan say you can't hang anybody after 5 years. This provision was saying you can hang them, such a person, after 5 years. You can at 10 years, but you have to hang them within 1 year of their exhausting all their appeals. That provision was taken care of the Privy Council in Pratt and Morgan. Then we went on in paragraphs 4, 5, 6, 7, and 8 to take care of cases like Hughes and Spence and Daniel Trumingham. And this is how we said we'll take care of them. Subsection 4 of the proposed provision which was put to the people. Parliament may prescribe relevant criteria for determining whether murder is capital on conviction for which a person shall be subject to the death penalty, or non-capital on conviction for such a person shall not be subject to the death penalty, provided that non-capital murder shall be confined to murder committed in sudden passion. Provided further that high treason shall always be a capital offense. Let me pause here to say, it began by saying Parliament may prescribe relevant criteria. The reason why that was done in making the determination, if a judge tried to do something which establish a principle, we give an interpretation to try and drive any holes in this, Parliament could correct it. The way the current constitution is written, we come with things like this here, the courts would declare them to be unconstitutional. But if the people decided in the changing in the constitution, they are locked tight. That is why we went. That's one of the reasons why we went in the referendum. Went on in 5. On the trial of a person indicted for murder, if the jury returns a verdict convicting that person of murder, it shall be a matter for the judge presiding at the trial to determine whether the murder is capital as distinct from non-capital. 6. If on the trial a person convicted for murder, the jury returns a verdict convicting him of murder, the judge shall hear evidence on the question whether the murder is capital as distinct from non-capital. If having heard such evidence, and on the relevant criteria referred to in subparagraph 4 of this section, the judge determines that the murder is capital, the judge shall impose the sentence of the death penalty, that is capital punishment, on the person so convicted. 7. If a person is convicted of murder, whether capital or non-capital, then after that sentence has been imposed, questions of mercy shall be decided by the mercy committee. And 8, sub 8, important, the carrying out of capital punishment in accordance with this section shall not be held to be inconsistent with or in contravention of this section. That is the one dealing with inhuman treatment or punishment, or section 26 of the Constitution, protecting the right to life, or any other provision of the Constitution. In other words, just in case there was any doubt, we tied it up finally, lock, stock, and barrel, so that the judges couldn't interfere with us carrying out the death penalty. So when anybody gets on the radio and says that it is nonsense to say that you can't impose the death penalty because it is on the books, it is on the books. But as I have said, the Court of Appeal and the Privy Council have driven a horse and chariot through our pre-1993 understanding of what the Constitution and the law was about, thus making it practically impossible to hang anybody, because unless, of course, it is the worst of the worst or the rarest of the rarest. And disemboweling Bertie Brown and cutting off his neck is not the worst of the worst, according to the Privy Council. Disembowel means you're cutting out the belly. Let the entrails roll out. Mr. Speaker, I know persons would say these provisions which were in the draft constitution, these provisions, couldn't you pass them in the parliament here and make them into an ordinary law? If you do that, they will be struck down as unconstitutional. That is the advice given to this government, including advice by distinguished Queen's Counsel in St. Vincent and the Grenadines. So I thought that it was necessary and desirable to speak to these matters as the Minister of Legal Affairs. And Mr. Speaker, I haven't practiced the law for the last 11 years. But in this matter, it's like riding a bicycle. I don't forget it. And I keep up with the reading, because I'm hoping to reach to the year 100 so that I could be celebrated like that. And we'll have to do some work still to take care, because the pension which I'm getting it might be able enough to hold me up to when I'm 100. So I'll still have to, the pension which I'll get. So, Mr. Speaker, that is the straightforward position. And anybody who says otherwise is engaging in demagoguery.